Okay, well, I think we will get started now. So hello, everybody, and welcome very much to this lunchtime webinar on the Institute of Directors consultation on a code of conduct for directors. I'm Anna Donovan, an Associate Professor of Corporate Law here at UCL Faculty of Laws, and a member of the Centre for Ethics and Law, which is, of course, bringing you today's webinar. Now, as the astute amongst you might have noticed, I'm not Professor Iris Chu, who was due to chair today's event. Unfortunately, Iris is unwell, so as well as sending her best wishes for a speedy recovery, I'm delighted to chair today's event in her absence. We're very pleased today to be bringing together a number of excellent panelists to discuss the proposed code, with the intention of generating discussion and debate so that these thoughts can be fed back into the consultation process, which is, of course, no doubt of great interest to many in industry and legal practice, as well as across the academy. So the order of proceedings for today is as follows. First to speak is Dr. Roger Barker, Director of Corporate Governance and Policy at the Institute of Directors. Roger will speak for about 15 minutes today to provide an introduction to the proposed code, and thereafter subsequent speakers, or indeed pairs of speakers, will have about 10 minutes each to share their thoughts. Following Roger's presentation, Dr. Pedro de Schilling, lecturer in environmental and financial law at UCL, and I will share the Centre's response to the consultation. We'll share our high-level thoughts, but we will make the response available in full on the Centre website after today's events. After Pedro and I have presented, Professor Joan Lockery, Professor of Law and Head of School at Queen's University Belfast, will speak. And concluding the panelists today will be Professor Ava Michaela, Professor of Law at London School of Economics. And I should make clear to Joan and Ava that we very much welcome their thoughts on the Centre response, as well as on the code itself. Now, whilst time did not permit me to do a full introduction of our wonderful speakers today, their full bios are available on the event registration page for you to take a look at. The final section of the webinar today will be a Q&A session. So throughout proceedings, do please submit a question via the Q&A function, because then I'll be able to collate them at the end and then put as many questions to the panelists as possible in the time remaining. So without further ado, I'm very much delighted to hand over to Dr. Roger Barker, as our first speaker today.
Anna, thank you very much for that introduction. And I just want to say a big thank you to everyone for taking the time to join us today and to discuss this initiative. Maybe what I will do is start by putting up some slides, if I may. I'll try and share these. Hopefully this will go okay. Let me have a look. There it is. And I'm hoping that you can see all of this. I hope that's all coming through to you.
Yeah, perfect.
Yeah, wonderful. So let me just start off perhaps with describing the background as to why we have decided to publish this proposed code of conduct for directors. Well, I think there are various things which motivated us. I've just put here on the screen the objects of the Institute of Directors according to its Royal Charter, which are very much targeted at promoting two things: integrity on behalf of directors and enterprise. And you can see there within the specific objects, it is a key mission of ours to promote integrity as well as professional competence on behalf of directors, to promote the study of corporate governance, good governance, and good directorship. So this to us was something which was very much aligned with what we're there to do. Some other good reasons, though, which motivated us in this endeavour. The first was that we conducted a poll of IOD members about 18 months ago, and we asked them the question: do you think directors or director equivalents should be subject to some kind of code of conduct, whether that be a voluntary code of conduct or a mandatory code of conduct? And 78% of respondents said that they felt that they should. So, and looking at the sort of feedback we received in that process, our members were very keen to try and professionalise the role of directorship, to get away from this feeling that being a director was just another step on the career ladder, which you kind of landed in at a certain stage of your career as you were appointed to be a director at a certain organisation. That actually being a director was something qualitatively different from a senior management role. It's a governance role. And it needs a very specific set of skills and competencies. And it really actually, being a director, to be a director, you were a part of a group of individuals who were fulfilling this very specific role. So if you think about what are the common features of any kind of professional framework, well, one is generally a kind of core body of knowledge and expertise which one should acquire. Another is generally a framework of conduct, which normally is embedded in a code of conduct, and you certainly see that in other professions, whether you're talking about the accounting profession or law or medicine or whatever it might be. So the question, I suppose, coming from our members was, why not directors? Why don't directors have such a professional code of conduct? And then I suppose the third motivating factor here was just what had been happening in the business world in the last number of years. And while I think we would argue that the overwhelming majority of directors, of business leaders, are extremely responsible and behave appropriately as directors in most situations, there are some high-profile instances of poor conduct. And I think we all know which ones I'm talking about. I mean, I've been watching with great attention the Post Office Horizon inquiry recently, but of course there have been the collapses of other organisations like Carvalho, BHS, and so on, which somewhat tarnish the legitimacy of business leadership and can lead not only to a loss of trust, a lot of loss of confidence in the specific organization's concern, but also have externalities for business leaders as a whole, for the business community as a whole. And losing that trust, I think, is a very serious thing. I mean, at the organizational level, it means that you don't attract the best people, the people that can really take your business forward. You're not able to win business partners that you would like. And at the societal level, if society, the general public, doesn't trust business, then that essentially is a mandate for policymakers to say, well, we need to circumscribe now what the way in which business leaders behave. We need to have more regulation. We need to more tightly control what they do. And certainly I'm of the view that that is not an economically optimal way to run organizations, that actually in principle, the board of directors as a group of people should be best placed to take into account all the range of complex information and objectives of their organization and make the best decisions in the interests of their organizations. And so there's a threat that if you don't behave well, you'll lose that freedom to act, and that will be negative for directors. That will be negative ultimately, I would argue, for our economy. So to address this, the IOD set up a commission which was chaired by Lord Ian McNicol of West Kilbride. There were 16 commissioners comprising a range of different figures from the business world, people serving as directors, some leading legal figures as well, people who advise directors were represented strongly. And we convened as a commission over a period of about 6 months, and then producing the final draft code of conduct in May of this year, which is now out for consultation. And you can see there from the forward from Lord McNicol and also the Director General of the IOD that this is all about winning back trust. And we hope that when people look at this draft code of conduct, in many respects, they will look at it and think, well, this is just common sense. This is just what any responsible director would do. It isn't rocket science. And they will also, we hope, be able to use it as a yardstick, a tool, a resource, which they can reflect on when they're in the midst of complex situations, often where you have to make quite difficult and controversial trade-offs between different interests, that they can use this as a reflection tool. And also, I think another area where I think it could be very useful is if you are a new director, you're coming to a new board, you're trying to fit in, you're trying to understand the way things are done around here. And perhaps things aren't feeling right. Maybe people are behaving in a certain way, which makes you uneasy, or really is not what you would expect. This, I think, also is something that can be used as a reference point, both internally for the director and also as a source of challenge for the rest of the board, in terms of how should responsible directors be behaving in this situation. This code of conduct has articulated what society, what the general public generally expects of business leaders. Are we aligned with that? So that, I think, gives you an idea of how we approach this initiative. A couple of points I want to address here relating to the code, because some people, of course, when they heard about the code, they came back with the arguments, why do we need this code? We have the UK Corporate Governance Code, and not only the UK Corporate Governance Code, but many other governance codes relating to specific sectors across the economy, related to charities, in the public sector, in the NHS, and so on. Surely that really is all of the guidance and best practice that is needed here above and beyond the law. What I would say to that comment is that, I mean, aside from the fact that, of course, the UK Corporate Governance Code only relates to premium listed companies on the London Stock Exchange, so very large organisations. But what I would say to that is that corporate governance codes are really about the structure and functioning of boards as a whole. They are not really directed at the individual director's conduct. So we very much the Commission saw the code of conduct for individual directors that we were developing to be complementary to the UK Corporate Governance Code. So not to be overlapping or contradicting with it, but to be a complementary piece of the furniture, so to speak. And then the second point which has been made is that, well, yes, we also have in law, in the Companies Act, directors' general legal duties, which are their fiduciary responsibilities, which they have to fulfill. And surely that provides the framework of conduct for directors. Why do you need something else? Well, I would argue here that directors' general legal duties are very much baseline legal requirements. They don't offer much of a hint in terms of how directors should behave on an everyday basis in practical situations. They're talking very much about the duty of loyalty that directors owe to the company and the duty of care that directors owe to the company. But not really giving much practical colour to what reasonable conduct looks like. So the hope here with this code of conduct was that the code would help directors to fulfil their legal duties, but would also go beyond that baseline level to up the bar, up the standard of behaviour of directors. In a way which wasn't in any sense a legal obligation, because there is no intention here to create obligatory requirements or a legal obligation or a compliance requirement with this code of conduct, but would try to influence the prevailing corporate culture such that director conduct went beyond the law, but aligned much more with what society was expecting. So again, the feeling here was that what we were doing was going to complement um, the existing legal framework for directors. So let me just talk a bit about the structure that was adopted for the Code of Conduct. I mean, one thing about this Code of Conduct is right from the start, we've wanted it to be applicable to the directors of all kinds of organisations, so large and small, organisations in the private sector, the not-for-profit sector, the public sector, anyone who is fulfilling a director or director equivalent type role. We want them to feel that this is relevant for them. So that's obviously a huge range of organisations. So to be too prescriptive in terms of what we put in the code probably wouldn't have been the right approach. Also, we're not talking here about a regulated activity, like the accounting profession, for example, where if you look at codes of conduct in those type of professional arenas, they are extensive. They're very long documents containing lists of do's and don'ts in all sorts of very specific situations. And so, of course, directorship is not in that category. You pretty much anyone can serve as a director, subject to certain really minimalist threshold requirements. So taking all of this into account led the Commission to think that we need to have a principles-based approach to this code rather than something much more detailed, more prescriptive. And it took as its inspiration the Nolan principles of public life, which have been around since the mid-90s and which apply to leaders operating within the public sector. Now, of course, the Nolan principles in themselves couldn't have just been cut and pasted over because they're very much focused on doing things in the public interest. So they're particularly applicable, or they're only applicable to public sector oriented activity. So we needed to tailor what we were doing to potentially be applicable to private sector organizations and as well as public sector organizations and the not-for-profit sector. So the Nolan principles were a starting point, but obviously the Commission moved on from that in terms of its discussions. And this is what they came up with, these 6 principles of director conduct. 2 of them you will notice, if you're familiar with the 7 Nolan principles, 2 of them are the same as in the Nolan principles, integrity and accountability, but others are slightly different. We gave some thought to the order in which these 6 principles should be presented. And we felt ultimately that leading by example or leadership needed to be the first principle, because if a business leader can't actually demonstrate advocated behaviours and conduct in their own behaviour, then they have very little chance in influencing anyone else in an organisation or anywhere else to follow suit or to even believe that, that they actually mean what they're saying. So that's why that went first, and the others flowed on from that. Now, the overall structure of the code is in 3 layers. So we have these 6 principles of director conduct, and then sitting under each of them are a series of undertakings which we are inviting directors to commit themselves to. And I'll come on to details of those just in due course. But the 3rd level, which we define here as outcomes, are what we hope directors will achieve, both for themselves as individuals, but also for the organizations they're working in, if they apply in good faith the principles and undertakings of the code. And the primary one, as I've mentioned, really is trust. That's at the core of it. But we would expect many other positive benefits to come out of applying the code, such as good relationships with stakeholders, a good reputation, and so on, across a variety of levels. So that's the code framework. Now, what I'd like to do is just dig down a bit now into each of the 6 principles, so you can take a look at the undertakings which fall underneath them. Now, I'm not going to go through each and every one. And I hope that as you read them, because was certainly the intention, I hope that they seem pretty self-evident to you. And as I say, pretty much like common sense. So the leading by example principle, the undertakings which we're suggesting there, maybe I will just pick out the penultimate one there. That devoting sufficient time and attention to a role as a director is an increasingly important factor. It's been very obvious to me as I've been watching the Post Office Horizon inquiry, the kind of one of the first questions that Jason Beer KC or whoever it is asks the person in the inquiry is, what are the director roles were you pursuing when you were a director of the Post Office? How many others? Were you able to devote sufficient time and attention to your role as a director? Of course, most of the people in the inquiry say, "Oh yes, absolutely. I had plenty of time to do what was required." But I think nonetheless it highlights that is an important consideration that the individual director should reflect on in their role. Integrity, I think a lot of self-evident points there. It's, I think, very important to stress to directors, again, that second to last point, about the fact that resignation should always be in the back pocket of a director. If a director can't live with a decision, a strategy of the organisation, and they've put forward their perspective, they've tried to argue it, they've tried to persuade the rest of the board, as a matter of collective decision making, is going to go ahead with something else. And if you as a director can't live with that as a matter of conscience, or you just think it's fundamentally wrong or fundamentally poor governance, you need to have the option there to resign from the board. And it always slightly worries me if directors are in a situation where they depend so much, perhaps for their reputational livelihood, on being on a particular board. That's not a healthy situation for a board member to be in. Transparency. Second point, maybe I'll just comment on the second point there. Promote an open business culture which does not cover up wrongdoing or mistakes. That may seem to us here to be a very obvious point to make, but how often do we see scenarios where that simply isn't happening, where the prevailing mentality is we've got to cover up bad news, either to the external world or from the management to the board level or to shareholders. It's happened a lot of late in the NHS, but there are many other examples where there still isn't the healthy sort of culture which is open about mistakes and doesn't penalize them, which of course creates a very negative incentive to be open and honest. Principle for accountability. That principle is obviously a foundation of good governance. This final point caused some discussion amongst the commissioners. I think it's a very interesting one. Before you take up a board role, do you really have the skills and knowledge to make a good contribution and to fulfill your role on that particular board? I mean, for many people, it can be quite flattering to be offered a board position, to actually say, well, and be truly honest with you and reflect with yourself and be truly honest and say, this really isn't right for me. That takes some courage. Perhaps less courage for the people who really are in demand and who are serving on many boards. They can perhaps be a bit more hard-headed about this. Someone made the point at a recent webinar that we don't want this point to deter people who are perhaps in some way are starting on boards and feel a sense of imposter syndrome, that this might actually push them away from wanting to serve on a board, which would be a huge shame. So I think what we need to do is have in the guidance, this code, something which makes clear the intention behind what we're advocating here. Fairness, I think hopefully some self-evident points. One of the commissioners we had was someone called Liz Barkley, who's the Small Business Commissioner for the UK, who's very concerned with the issue of late payment of SME suppliers. So it was very important to her to emphasize the importance of the fair treatment of suppliers. The last point there about reward and recognition structures. Executive pay in particular is a very controversial topic. The main thing that we would say about it is whatever kind of pay levels you are thinking about, the structure that you use should be such that it doesn't incentivize poor conduct, poor behavior, or short-term perspective. So the commissioners felt it was important to include that. And then finally, responsible business. And the thinking behind this principle is the view that directors and businesses are not operating in a vacuum within their own little closed community for their own benefit. They are situated in society. The decisions that they take have implications for the communities that they operate in, the environment, climate, the planet. And directors really need to think about that and take that into account. And so these undertakings here were very much trying to nudge directors to make that an important part of their conduct. So those are the 6 principles. The consultation, as I've mentioned, runs until 16th of August, and on the public consultation document, there's a way in which feedback can be submitted. And thank you to the UCL Centre for Ethics and Law for producing some feedback, which we really appreciate. The timetable of this is that we're going to reflect on the feedback at the end of August into September, then hopefully approve the final version of the code in late September, and then publish it in October. I've been really delighted in how much feedback we have been getting and how many submissions. This is a bit of a snapshot of who was responding as of a few weeks ago. You can see it's mainly directors, although this consultation has been open to the general public because we're trying to craft this code to reflect the expectations of society. So it's important that everyone really has the opportunity to participate. Different sectors are responding. There's different views there you can see about whether there should be some kind of public declaration or disclosure of the adoption of the code. I should just mention that at the moment, our intention is that when this is published in October, it will then be available to directors. It will be out in the world and for use as a tool and a resource. And we will encourage directors to signal or announce their commitment to the code in any way that they see fit. They could do it in their annual report. They could just do it on social media. They could release a press release, whatever way they choose. But thereafter, we don't plan to police this code. You know, the IOD is not going to set up an investigation branch or a tribunal and a sort of disciplinary committee, something of that nature, to hold directors to account in terms of their compliance with the code. That is not what we plan, certainly not this stage of the game. The way we will see this working is if you as a director declare that you are committed to the code, then really the stakeholders of your organization, the general public, the media, they will be the people really that should, in a sense, hold you to account in an informed sense, rather than in a sort of formal process.
Roger, sorry to intrude. We do need to bring comments to a close in a moment. Thank you.
Thank you. And in fact, well, no, I've finished. That is yeah. So just my final thought. This is just a sort of summary of some of the feedback we've been getting. But I'll send you the slides and you can have a look at that in more detail. So why don't I stop now, Anna?
Oh, thank you so much. And sorry to overspeak. I'm just
No, oh gosh, I've been talking for too long. I do apologize. Please forgive me.
I was too absorbed. That's a problem. It was too interesting, but time is not our friend today. And thank you so much for such an engaging and insightful overview of the code. We've certainly been very interested looking at it, thinking about it, and even more so hearing a bit more of the thinking behind it. As I mentioned at the outset, Pedro and I will now share an overview of the centre's response, and I'll have a high-level look at some of the key themes, the general themes in our response, and then Pedro can take you through some of the specific issues that we reflected on in our response. And as I've said, that will be available in full on our website. Before we get into some of those general themes, I think the overarching point that it's critical to make is that we do, of course, fully support the objectives of the IOD with regard to the code. As Roger was saying, the scandals of late and not so recent really do tarnish trust in the sector, and as Roger was saying, can lead to that kind of reactive ad hoc regulation, which often doesn't serve anybody. So to the extent that the code is seeking to restore public trust in companies, to improve organisational culture, those are objectives that are very close to the centre's heart, and something that we do fully endorse. We did have a couple of comments on the code, and again, I'll share some of the high-level themes before handing over to Pedro to look at some of the specific legal issues and risks. We did start by reflecting on this question of purpose and impact that Roger kindly touched on, namely that to really ensure meaningful compliance with the code, it's helpful to be clear from the outset what the purpose and the specific intent of the code is. You put another way, if the code was in place at the time, how would it have impacted those scandals that Roger mentioned? And the reason we raised this in our response, and I'm very grateful for Roger's thoughts on this, was, well, we see that the code is very clearly written to target individual behaviours. And there is, however, a wealth of literature saying, well, organisational culture, organisational behaviour can be a very different phenomenon to how the individuals acting on its behalf are intending to act, and the values that they may bring or try to bring to the organisation. And so for us, it would have been useful to think about, well, how can the code support those individuals who are trying to achieve its values when faced with this sometimes insurmountable challenge of how the culture of the organization itself misaligns? And so it was really interesting hearing Roger's comments on the relationship between, for example, the corporate governance code, looking more to board and organizational level, and the code of conduct itself. So those are questions that we felt on our reading, and it's interesting to have heard Roger's comments on that impact, and perhaps extended all that on organizational culture vis-a-vis the individual. We did then think about this question of the governance relationship that the code seeks to create. Is it a relationship between the IOD and the individual, or between the individual director and its organization, and seeks to create, or in fact creates, regardless of intention perhaps? And if the latter, if between the organization and the individual, we are concerned that that might give rise to additional questions of risk and liability that Pedro will come on to shortly. But if the former, if we are keeping our focus on the individual itself, that does then raise further questions itself, one of which being whether the code looks to create the professionalization of directors. As Roger noted, in this jurisdiction, there are very few qualifications, or indeed qualities, that a director needs. And there are policy reasons for that, concerning freedom of entrepreneurship, amongst others. And whilst I think few would disagree with the need for strong personal qualities in a director, and it was reassuring to see Roger say 78% of their members indeed were fully in support of this, if we move towards this gold plating or gold standard of directorial behaviour, it can move us away from those original policy objectives, which might need further reflection. And one particular concern for us here is, well, what if the code, for reasons I'll come on to, effectively becomes a default for directors where they feel obliged to comply with this? Does that create a barrier to entrepreneurship? Does it create additional uncertainty or risk or burden for our directors, particularly those of smaller organizations who might not have the resources to support their compliance? So again, just a point for discussion and debate, perhaps. Which does bring me on to the final general theme of our response before I pass over to Pedro around enforcement and oversight. As the code is clear, as Roger was very clear, there is no intention for this to be a code that is centrally enforced. This is something for stakeholder or public management. But that does raise in part the risk and the question as to whether directors do feel that they simply are obliged to, or they may wish to say, well, we comply with this code, we adopt this code, but without actually putting in the work to achieve the behavioral change that should follow. And that then gives rise to that risk of, can the code effectively be abused for reputation washing purposes? And the sad consequence of that being, potentially we have this very important instrument where the behavioral and normative impact is undermined because of poor compliance with its terms. So a very quick canter through some of the general themes that flow throughout our response. Like I say, that will be available on the website. And I'll pass over now to Pedro, who can talk about some of the more specific questions that arise and that we set out in our reply.
Thank you very much, Anna, and thank you very much, Roger and the IOV for the chance of commenting on such a rich instrument. Starting by expanding a bit on what Anna mentioned about the role of the code as a governance instrument, we do perceive, as she mentioned, some uncertainty as to whether the code as a governance instrument is individual-facing or organization-facing. If individual-facing, as she mentioned as well, we foresee some potential difficulties in evaluating change, evaluating what the code is achieving, especially in the long run, and more broadly, the code's effectiveness as well. So some sort of evaluation, some sort of a process later on could be helpful for that credible signaling of directorial qualities. If instead this is a more organization-facing code, so creating a relationship between the individual and the corporation, we foresee potential challenges with some of the principles, especially those that deal with matters that are usually dealt by the board's collective responsibility. In those instances, we see how some of those principles might affect directors' personal ownership or personal risks over issues that might be covered by the codes. In our response, we have singled out some examples from Principle 1 and Principle 2, and hopefully we'll be able to look at our response later in our websites. Our second more specific theme, which Roger very helpfully expanded a bit upon in his exposition, has to do with that layering within existing legal and soft law framework. So how does that potential interaction with instruments such as the corporate governance code, the weights principles, and directors' duties might work in practice? Here we think that in the instances where some contradictions, some conflicts could potentially arise, some legal risk might arise as a result as well. This has especially to do with some parts where we're not quite sure in some of the principles to what extent the code is simply restating or centralizing existing obligations to give that sort of more practical guidance for directors, or in areas where it might be effectively gold plating some areas. And we've singled out examples from conflict of interest management, rejection of bribery, and so on. This could potentially create a risk of raising expectations regarding the standard of compliance with the law, especially in cases where the code might be gold plating certain areas. And we see potential extra complexity when it comes to the broad scope of directors that the code is aimed at. So how that would play differently for executive directors, NADs, or in other instances, for example, dealing with smaller company directors linked to controlling ownership. In relation to some of the principles, we did discuss some more specific issues of legal risk. So some principles that can create the impression of enhanced but often unclear legal risk for directors, and whether courts, for instance, could potentially give a weight to adherence to the codes. We have discussed that specifically across different principles, but I'll bring one specific example from Principle 6, which deals with responsible business. This could raise liability questions as it's sort of mixing areas where there's very clear legal obligations. So for instance, rejecting corrupt practices, with other areas that are more marked by either soft law instruments or more limited legal obligations, such as in the case of sort of supply chain expectations regarding environmental impacts. To wrap up our comments, and again, restate what Anna has also mentioned, we do applaud IOD's thought leadership and agree that promoting good business practice and restoring public trust is absolutely crucial. And we do think that the IOD is in a very unique position to contribute to those topics. But we're also encouraging in our response the consideration of alternative and complementary options, which could include the code having a sharper focus on that directorial management of organizational culture, expanding work on targeted training for boards or specific kinds of directors in specific kinds of companies, or even considering more heterodox alternatives, such as having a shadow board in place. So once again, thank you very much for giving the chance to contribute, and very much looking forward to the remarks from other panelists as well. Thank you.
Thank you, Pedro. If I could now turn the floor over to Joan, that would be much appreciated.
Okay, and I have my timer on. Well, first of all, I just want to say thank you very much for inviting me to speak here today. And I very much welcome this initiative. Roger, your presentation was really thoughtful, and as is the submission by the Centre. I'm also going to focus primarily on the purpose and the function of the code. And if I've got some time, I'll talk about some specific provisions. Turning then to the purpose and function of the code as identified by both you, Roger, and by the Centre. Rebuilding trust in business. So my comments on this are that to rebuild trust in business by changing culture, the code's going to need to address behaviours that have eroded public trust. And certainly the code at the minute sets high behavioural standards, higher than, and as we've heard from the Centre, in a number of respects different to the legal requirements that directors have. The reservation I have is that, on one view, the potential for it to mitigate the behaviour failings that were exhibited in, for example, Carvalho, seems challenging, because in Carvalho, the directors didn't even meet their baseline legal duties in a number of respects. And if a director's not going to meet the minimum standards represented by the law, there's going to be a challenge in getting them to meet the higher standards set by the code. Now, it's that behaviour that is eroding public trust. But I do think the code has the potential to assist in a number of respects, and I want to focus in on one principle, which is the principle that requires directors to state they're going to commit to obeying the spirit of the law. Now, this is potentially quite a contentious principle, but even having a debate about it could be helpful in addressing a particular culture that is causing problems, because even making this statement can challenge norms of behaviour that create a greater risk of the law being breached, and a culture that perceives it as legitimate and justifiable and possibly even necessary to engage in legally aggressive conduct, that while it doesn't technically breach the law, it breaches the spirit. In other words, conduct that's designed to knowingly circumvent the law in order to pursue profit and shareholders' interests. Arguably, this approach breeds contempt for the law, but perhaps even more pertinently, the problem here is that those who think that who take the approach that's legitimate to stretch the spirit of the law, to exploit, stretch the letter of the law, to exploit the law, are more likely to get it wrong. They are more likely to cross the line and actually break the law. And arguably, this has occurred in a number of instances. One can think about an ongoing scandal where perhaps this has happened in relation to disclosure obligations. So I think that's a good thing. And so far as this provision challenges that, it could reduce the possibility that the line will be crossed, law breached, and public trust eroded. Of course, the second way that the code could seek to restore public trust is not by changing behaviour, but by signalling to the public what the business community already considers to be good behaviour. And Roger, I think you've flagged that up. The code should be viewed as common sense. What this means is that when scandals do occur, it allows the business community to signal that those responsible for these scandals are outliers. And certainly when I interviewed directors under the auspices of the Institute a while back, that was the sense I got, you know, the people who were the wrongdoers, we don't want to be associated with them. We want to clear water between us and them. But for this message to be meaningful to work, there does need to be, I think, a clear demonstration to commitment to the code's values and widespread take-up. Otherwise, there's a risk it could be perceived as window dressing and public trust could be undermined. So I was very interested in stats came up about whether directors should be required to make a public declaration of their adoption of the code. And the answer would be yes, if it's going to rebuild public trust, I think they do need to. I don't have time to say much about educational, but I would be happy to put that in a written submission. I do want to talk about the accountability aspect of it. The need for accountability has previously been linked to restoring and protecting market trust, with the idea that accountability should deter undesirable market conduct and will reassure the public that steps will be taken against those who act in untrustworthy fashion. So in other words, proper accountability is necessary to increase the chance of the code being effective in promoting market trust and cultural change. And the difficulty is accountability is a very difficult concept to define, and it's not clear to in what sense accountability is being used in the code or the consultation document. It seems to be getting used in the sense of responsibility, which is not quite the same thing. One study on accountability in corporate governance identified it as a process that involves a number of stages. And importantly, one of these, and I think that the Centre has definitely picked up on this, the possibility of consequences, these can be positive or they can be negative, being visited upon those whose behaviour falls below required standards. And I've heard, Roger, you say that it's not about sanctioning directors and so forth, but for accountability to really be effective and linked to market trust, there needs to be some kinds of consequences. And certainly the code, the section that you've got in the code on accountability envisages some aspects of the process of accountability. And the code itself provides a standard against which directors' conduct can be evaluated as satisfactory or unsatisfactory. But what's not clear is what will the consequences be if someone breaches the code, signs up to it and breaches the code. I'm hearing a market response, but I'll come on to that, the adequacy of that in a minute. So in brief, without adequate accountability, it's less likely that the code will be effective, and more consideration, I think, does need to be given to that. And this is really linked to my next point, and the point, Roger, again, that you raised, which is about getting your house in order and a business getting its house in order to avoid prescriptive regulation that you see quite often called for in the wake of corporate scandals. In my view, and I'm not supportive of prescriptive regulation that regulates directors' behaviour more. But the kinds of accountability, the kinds of regulation that's often called for, or certainly what the public call for in the wake of corporate scandals, is better accountability. And what they really mean there is effective sanctioning of directors who cause harm, whose management of the business causes harm to others in the wake of scandals. And I don't think the code cannot and should be looked at to address that gap. I don't think it's seeking to do so or should be seen as seek to do so. The code addresses a different issue, which is an effort to change behaviour to avoid scandals in the first place. And of course, there's always going to be scandals and director misconduct. And where there needs to be effective sanctioning. Otherwise, as the consultation makes clear, there is a risk that public trust in business and our institutions more generally will be eroded. So I don't think the code should be relied upon as an argument against effective sanctioning, if that is part of the concern. Turning to professionalising, I absolutely agree with the Centre submission on what they've said about professionalising, and the fact of the matter and the goal of the code in professionalising. It's not necessarily a bad thing at all, but it just needs to be, there are implications and there are arguments that go both ways on the merits of directors professionalising. And certainly it could have implications substantively and procedurally if any claims are brought against directors for, say, breach of their duty of care. Because viewing directors as professionals guided by the code could certainly raise the baseline standard of care, skill and diligence expected of them by the law, which arguably carries a greater risk of directors then being found liable for breach of that duty. However, and this is sort of a reality thing, levels of litigation against directors for negligence are really very low. And when a case is brought, the courts do show significant deference to directors' judgments and are very slow to find them liable in negligence. So long as directors haven't acted irrationally and can't explain their actions, haven't abdicated their duties, haven't ignored red flags, haven't failed to act when they should have done, or haven't failed to inform themselves appropriately before making a decision, in fact, they're unlikely to be found liable. So the cost of professionalising from this respect may not be very great. Another procedural risk arising from viewing directors as professional is that it could increase the cost of any litigation that are brought. I mean, presently, when directors are sued in negligence, the courts are really divided as to whether expert evidence needs to be brought on the subject of whether directors are negligent. Some courts say, yes, we need expert evidence, and other courts have said, no, they're not professionals, we don't need it. But if they're viewed as professionals, then if litigation does occur, it's more likely, I think, that the courts will require expert evidence, which could increase the cost of litigation. And I think, have a little bit of time to say something about specific provisions. I agree with the Centre on the provisions, particularly which ask directors to seek independent advice on matters of concern at an early stage and to make decisions on an objective and evidence-based basis. I do have some reservations. It is definitely the case that directors are more likely to be found liable for breaching their duty of care to the company, where they failed to take advice before making a decision or failed to properly inform themselves before making a decision. But whether it's appropriate to seek advice does depend very much on the particular circumstances in which the decision is being made. Does it have to be made very quickly? Does the cost of seeking advice outweigh the perceived benefits? So long as directors carefully consider whether they ought to seek advice and they take an active decision on this, they're unlikely to find them liable. It's a matter of judgment. So I do think it would be helpful for the principles to be adjusted slightly and more nuanced, so that the code complements and doesn't contradict existing obligations. And I'd say something similar about the principle asking directors to avoid prioritising the short-term financial interests of shareholders above longer-term interests of the organisation. Very laudable principle. The law doesn't require this. The law requires directors to have regard to the longer term, but doesn't require them to act in the longer term if in their good faith business judgment, that's not what's needed in the circumstances. So it's about nudging. And I just think that the principle could be adjusted to make it clear that that's not required of directors, but it's good practice. Thank you.
Thank you very much. Thank you.
Thank you, Jo, much appreciated. Just to mention to the audience, we are running about 5 minutes or so over, so do bear with us, but we appreciate if you need to leave on the hour. But on that, I'm delighted to pass over to Professor Eva Michaela.
Yeah, thank you. Thank you very much for inviting me, and also thank you for your all of your presentations. So my reaction to the Code of Conduct, I think I'd like to make a very high-level comment to say it's an important step and an important complement in this change of narrative that has happened since the financial crisis, and kind of pushes back what happened in the early 1980s when we moved from or when we moved to business is about maximizing things, business is about greed, being good, and that was sort of that narrative, and that has been pushed back following the financial crisis. So I would say it's an attempt, a normative attempt at modifying social norms. So the idea is to redefine at a societal level, also at the level of the companies themselves and of the directors, what is it to do business in a good way? So what are the societal expectations that we have of what good business is? And I think it fits generally well with the British Academy's Corporate Purpose Project. It fits well with the new renditions of the Corporate Governance Code, the Stewardship Code, all that pushes into a direction where we change the way we think. And while I was listening to the presentations, I looked up when the Institute of Directors was founded, which was in 1903. So what I'm going to do immediately after is find out what you did around the late 1970s, early 1980s in terms of influencing the narrative there. That would be a fun comparison, but that's a side note.
It's a different world.
Yeah, very different world, and I'm sure you were very much.
I wasn't there.
Into maximizing and all that kind of stuff. Okay, so then on corporate conduct, I'd like to echo Anna's comment about corporate conduct is more than individual behavior. And I think maybe the code could do a bit more to acknowledge that. And there is I've recently looked at, there was an empirical study of 25 largest European banks and their scandals, and they were looking at what was it that triggered all this wrongdoing, and they found what was very important were the systemic. It was a systemic failure. It was a procedural failure. So this bridge between individuals feeling bound to ethical principles, and then that feeding over and affecting the way the organization is run, what the procedures are, what the systems are, what are people rewarded for, and I think that is a sort of a bridge that needs to be perhaps built a bit better. And then I'd like to connect to Aristotle, who said we become just by doing just things or just acts. And the point is, being ethical is something that is a habit. And the question is, how do we jump this bridge from here are some principles to here is what we do as a normal way of thinking, as a normal way of acting? And that is a big bridge to build. In particular, going back to the study about the 25 banks, many of them had codes of value and conduct to which their employees were bound. So I think thought needs to be, or we need to think about how we move on from here are the principles to here is what we do normally. We don't think about it. It's like brushing teeth, combing hair. This is how we run things. And I think, of course, the Institute of Directors is ideally placed to spearhead initiatives like that. Another comment, and I think maybe not a straightforward one, is how does this sit with entrepreneurialism? Because business is about the bottom line. Business is about having inputs and making a profit. And it's not, so we would like to move away from maximizing things, which is maybe the wrong way of conceptualizing what business should be doing. But there is a bottom line. And because if you read the code, you'd be forgiven for thinking this is about a school, it's about a hospital, it's about a university. And how does this fit with profit? Because profit is important. This is private enterprise. This is about succeeding in a market. And that connection between the code and the environment in which it should operate isn't clear. And perhaps if it was clear, it may have a better chance of being absorbed. And then a final point, also a behavioral one, is about having a code can have a counterintuitive effect. And the counterintuitive effect is, so we've got an ethics code, we've all agreed it's the code, we've done the ethics, we've dealt with conduct, that's it, finally, let's move on. And I don't have a solution to that, and I don't think it's a reason not to have a code. But it's also something that, of course, the Institute of Directors in promoting good conduct can do research on what can be done to not have this code as a sort of legitimator of let's forget about good conduct. And that's it. Thank you very much.
Thank you, Ava, and thank you to all of our panelists today. So interesting is the debate and discussion. We are over time already, so I will bring things to a close. We do have one question and one comment, which rest assured I will send to Roger after the event so that the IOD can engage with all of those after the webinar today, and do obviously get in touch with us directly if you wish. The last point to make is, as Roger said, the consultation is open for another few days. I think it's the 16th, is it, Roger? Yeah, the close. please do share your thoughts with the IOD, and perhaps having reflected on some of the panelists' comments today. So thank you very much to all of our speakers, and thank you to our audience members for joining today's event. It's been great to consider such an important and timely topic with you all. And yes, do get in touch with the Centre should you have any further questions and comments, and we can pass them on to Roger and others as the case may be. But thank you very much to everybody once again, and wishing you all a good afternoon.